289. What is a constructive change?
To understand constructive changes, a brief discussion of the changes clause included in government contracts is necessary. John Cibinic, Jr., and Ralph C. Nash, Jr., write of the changes clause that most government contracts include a changes clause which gives the government the unilateral right to order changes in the contract work during the course of performance. In exchange, the contractor is promised an equitable adjustment in the contract price, period of performance, or both. The changes clause is one of the most important standard clauses contained in government contracts. The clause is central to the government's contractual approach, since the provisions of the clause directly affect the rights and obligations set forth in numerous other clauses. For example, problems concerning inspection, acceptance, warranties, defective specifications, impossibility of performance, and acceleration of performance will almost likely be involved with the changes clause. The four basic purposes of the changes clause are: 1. To provide flexibility by giving the government the unilateral right to order changes in the work to accommodate advances in technology and changes in the government's requirements. 2. To provide the contractor a means of proposing changes to the work, thereby facilitating more efficient performance and improving quality of contract end products. 3. To furnish procurement authority to the CO to order additional work within the general scope of the contract without using the procedures required for new procurements. 4. To provide the legal means by which the contractor may process claims through the administrative disputes process. The administrative dispute process is also known as the constructive change order doctrine. In this context, the word constructive is derived from the word construed. Therefore, the use of the word constructive means that a change to the contract has occurred, and the change can be construed or inferred to have the same effect as if the CO had issued a written change order pursuant to the changes clause of the contract. As Cibinic and Nash state. When a contractor performs work beyond that required by the contract and it is perceived that such work was ordered by the government or caused by government fault, it is usually found that a constructive change has occurred. Under common law contractual analysis, such fact patterns would more likely be placed under theories of implied contract or breach of contract. However, the administrative procedures developed for the resolution of disputes in federal contracts prevent the boards and courts from using these theories. Hence, the alternate theory, or doctrine, of constructive changes. They further note, the doctrine of constructive changes is the basis upon which boards of contract appeals and courts have held numerous types of government action or inaction to be within the scope of the changes clause, thereby entitling the contractor to an equitable adjustment to compensate for the additional costs generated by the government's conduct. Both the government and the contractor benefit from the relatively efficient and inexpensive method of resolving constructive change claims through this administrative disputes process. Moreover, categories and examples of constructive changes include disagreements between the parties over the contract requirements. Where due to the government's misinterpretation of a contract provision, a contractor is required to perform more or different work, the contractor is entitled to an equitable adjustment pursuant to the changes clause. Examples: 1. Suggestions by government personnel that the contractor perform work in a specified manner. 2. Rejection of a method of performance selected or used by a contractor that was not otherwise precluded by the contract. 3. The government's refusal to permit use of an item equal to a specified item where the contract contained an or equal clause. Defective specifications. When the government provides defective specifications. The contractor incurs additional expense in attempting to perform in accordance with those specifications. Courts have ruled in numerous cases that the costs of a change issued to overcome defective specifications should include costs incurred from the inception of the contract, since the contractor had incurred expenditures made useless by the faulty specifications. Example: the defective or impossible specifications cause confusion and increase the time and cost of performance until the specifications are corrected or relaxed. Acceleration, which is a speeding up of the work in an attempt to complete performance earlier than otherwise anticipated. In some instances, a contractor may accelerate on its own initiative to assure completion within the contract schedule or for some other purpose. The costs of such acceleration are, of course, not recoverable from the government,